Chapter 5, we're kind of skipping through to the meaty concepts of Law 2 here. We go from ethics now to switching gears to a solid law content chapter. And intellectual property is to be distinguished from two other kinds of property that we study in business law. Can anyone tell me one of the other ones? There's intellectual property, but what's one of the other ones, Adam? You think of that? Just broad types of property that we studied. Land, what do we call that type of property? If you were to get into buying and selling land, what would they call you? A realtor. So what do they call land? Real estate. So it's called real property, right? So the first broad category of property is real property. It's just the way it works. So this is kind of like unreal property, right? Intellectual property. Okay, good way to think of it. The second one, there's real property. That's the land and everything that is bolted to it. So buildings and fixtures go along with real estate. So you have to ask yourself if some of these things that are attached to the building are meant to go with the building if we sold it, or meant to be pulled out and kept with us. If it's not bolted down, then it's not real estate. Therefore, it is personal property. Okay, personal property is stuff, things that you carry or hold or drive or that aren't real estate. But they're tangible, they're physical. So real estate and personal property have something in common. And that is you can touch them, move them, do things with them. Right? That's why we needed a third category. And in American law, we have this thing called intellectual property. Trouble is, for the most part, you can't interact with it in the physical realm. It's intellectual. It's visual most of the time. Those kinds of things. It's what you hear, what you see, sometimes even what you think, right? That's intellectual property. There are three broad categories of intellectual property. Just give yourself these notes as a mental peg, okay? This is Dr. Davis's 2-second summary of intellectual property. All right? There are three broad categories: copyrights, trademarks, and patents. Those are the three main types that in American law are protected. Now, yes, we will talk later in the chapter about trade secrets, okay, and some other kinds of things. But when it comes to legal protection and the Constitution, which we'll look at in just a second, it's really those three: copyrights, trademarks, and patents. Those are the three broad categories that we'll look at. What is intellectual property? It is any property that is the product of an individual's mind. The product of your mind. Anybody ever written a song? Like even informally. I'm not talking about like you're Chris Anderson or whatever, and you actually get things. You ever thought of a tune or something like that, or even some words to go along with it? It could be dumb. I think of songs all the time when I'm trying to get my kids out of bed. All right, kids, time to get out of bed. All right, we come up with things that we sometimes goofy, sometimes serious, but you've come up with a song. Okay, great, and it's in your head for a while, right? Before it does anything else or goes anywhere else. And let's say we're writing a song and we got this tune just kind of stuck in our head. Is that protected under the law? Not yet. Not yet. When does it get protection, do you think? Like how tangibly does this thing have to exist before the law protects it? Because like we're saying here, it's the product of an individual's mind. And we're studying it in business law, and by the way, it's mentioned in the Constitution, so there must be some level or some place where it gets legal protection, but not while it's just in my mind. So you say, okay, what has to happen is it has to come out of your mind through some way. What are some ways it might come out of my mind? Okay? Say, well, we got a lot of ways we've seen you go out of your mind, all right? But the song, what are some ways that could leave just my brain and, yeah, what do you think? I mean, there's some possibilities here. What are they? Give me some.
Write it down.
I could write it down. So if I knew how to score music, I could get the lines and all of that, and I could write the notes, and I could put out the tune, and I could write down the words. And truly, if I do that, and here's the magical thing about the law in this area, the minute I write it down, I now have legal protection. It was in my mind, now I wrote it down, it's got legal protection. Now, that's the ultimate way to memorialize a new song. But I would guess not too many songs go directly from the brain to the hand to the paper. What do you think happens a few times before that? What do you think, Tyler?
You tell people?
I tell people, I wrote this song. Oh, really? What's it sound like? Can't say. I'm just going to tell you about it. Okay? Just telling people about it or what? What else? Come on, ladies. Bail these guys out.
You actually collaborate.
I collaborate with people. I get... I call up Andy Gleiser and I say, hey, I hear you write songs. I got an idea for a song. Let's collaborate. Okay? At some point, he's going to say, what? Let's hear it. Right? And let's say I got him on the phone. I say, okay, well, I'm not much of a singer, but I'll hum it to you. Okay, hum it to me over the phone. And he says, okay, yeah, I think you got a winner there. I tell you what, my people will call your people. We'll get together. And I never hear from him again. But I hummed it to him over the phone. What do you think? Protected now? I haven't written it down yet. I didn't go to the ultimate step. I just hummed it to somebody over. It's not in my mind anymore, right? It got out. What do you think? Should we protect that? The law says not yet. Not yet. We're looking for a magical bright line that says you've now got legal protection because you did something. And that's what we're going to search for in this idea of intellectual property. When it comes to music, when it comes to anything really, and you can kind of write this down, the intellectual property gets protection when it is reduced to a tangible, repeatable medium. It gets protection when it is reduced to a tangible, repeatable medium. You say, man, that is some vague words. Well, it's intentionally broad. I did not say that it had to be written down. But truly, let's test that. Is writing it down, reducing it to a tangible, repeatable medium? Yes, I can get that sheet music. I can read it. I can sing it. I can give it to somebody else. They can read it. They can sing it. We could give it to two people in two separate rooms, and then bring them together, and for the first time, tell them, sing it, and they will sing the same thing. So it's repeatable, right? It's tangible. It's there. We can see it. Cool. Let's take it one step further. You've got an iPad, got a music score, a music noting app, and you say, I'm going to, instead of writing that on a piece of paper, I'm going to click and tap and put them in that way. Which word in my definition? There are three operative words in my definition, and they are tangible, right? Reproducible, and medium. So which one of those is at issue with the iPad? Is it reproducible? Sure. I can email it to somebody. Is it a medium? Yeah, it's a medium. Is it tangible? That's the one that's kind of in question, right? How tangible does that have to be, and in what form? The answer is electronic medium counts as tangible. So tapping on the app and putting my notes in that way, perfectly fine. Great. Okay, cool. Let's try to back it off a little bit. I don't know how to do scoring music, so my father-in-law is hilarious. He is a PhD in communications. He taught PhD level courses at Southern Illinois University until his retirement a couple of years ago, and has shepherded doctoral students all over across the world, presented papers, and just is kind of an expert in this area with advertising and communications. So he's a pretty cool guy. But he's not. Sound recordings count. So we're good. Now, let's say that he goes to an old-fashioned church. They don't even really have a recording booth or anything like that. They don't record the sermons. He sings special music in the church once a month, and he decides to stand up, and before he's recorded anything, he stands up and says, I'm going to sing a song I wrote this week. And he stands there with the piano playing, and he sings, and then it's over with. Is the song copyrighted yet? Is the song protected by intellectual property? No. A performance without a recording, just singing it or communicating it without reducing it to a tangible, reproducible medium, doesn't give you the protection. Okay? Now, I'm talking broadly here. It doesn't get you patent, trademark, copyright, nothing. Now, you can protect a lot of different kinds of stuff. I mean, we think about books and software and music and movies as being the big ones that people talk about most. But you can trademark dance moves. You can. Somebody says, hey, that's my move. He could be right. You can trademark choreography, to be more precise with that. You can trademark lighting design. You can trademark colors used in association with shapes. You can even trademark sound design. I mean, we know it can be copyrighted, but you can actually trademark it too. So there's a great deal of flexibility with the kinds of things that the law will protect. Where does it come from? Well, it comes from the Constitution. In fact, page 2 of the Constitution, if you zoom in, it says, Congress, I'm sure you can't read that. It says, Congress, Article 1, Section 8, shall have the power to, and listen to what the purpose of intellectual property law, theoretically, is. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. It's handwritten onto our Constitution right there in the red box. That's where the power comes from for this entire area. Now, I won't give you too much of a history lesson today because I've turned over a new leaf and this is all supposed to be very interactive. But it's very interesting if you go back and look at the history of the founding of our nation, that nearly as much time and energy went into this clause of the Constitution than anything else you see. Whether it's the protections of religious liberty and free speech and the right to bear arms and all those other kinds of liberties, nobody disputed. You notice, where is the free speech protection again? What's that part of the document called? What's that? The Bill of Rights. The Bill of Rights. And remind me, is the Bill of Rights on page 1 or page 2 of the original Constitution? It's not. Why? It's an amendment, right? In fact, it's the first 10 amendments, right? Free speech didn't make it into the main document. But patent and trademark law is right there. Article 1, Section 8. They didn't argue about what they wanted to do in this area. Why? Because the European systems that they came out of did not respect intellectual property rights. And that was a major gripe that they had with the crown. You understand, in a monarchy, if you invent something, you don't own that. The king owns that. if you write something, you don't own that. The king owns that. So it gives you very little motivation to come up with anything unique and anything innovative because you can't profit from it. Immediately, as soon as it gets popular, as soon as it's realized that that was a good idea, it's stolen from you and somebody else gets to profit from it. So that's why we had the Dark Ages for so long. You wonder why it took so long to invent our way out of the Dark Ages? Why the Enlightenment took so long to take off? This is actually one of the very good reasons why that was the case. And so for hundreds of years, there was no innovation. Things were done exactly the same as they always were. And in the United States, when they put this new grand idea together, they said, this has got to be one of the tenets. This has got to be something we put high up on the shelf. You understand, in communist nations today, same thing. There is zero respect whatsoever in China for intellectual property rights. Literally, right outside the Apple store on the sidewalk is a guy with a table selling knockoff iPhones. And they can't do anything about it. If you were doing that in the United States, the federal government would literally come and throw you in jail. Have you ever bought a jersey for a team on eBay? And did you ever notice that the officially licensed, Reebok football jersey, if you wanted to try to go online and get a replica Reebok brand, or is it Nike now, jersey for Aaron Rodgers and the Green Bay Packers, that was going to cost you over $100. Or you can go on eBay and get the same exact thing for about $25 plus $6.99 shipping. And I promise you it's coming from Hong Kong or somewhere overseas where they are sending you a knockoff. There's not the respect for it. Now, if it gets caught in customs, you're going to be out that money. Okay. But great way to save money if you're looking for it and you don't care about the hologram that they put on the official one. So this was very key and very foundational, and that's one of the reasons why the United States, over its entire history, has led the world in innovation. But remember, what was the purpose? To promote the sciences and the useful arts. That's the constitutional purpose. My fear is that we have gotten way far away from that purpose, and that the law continuously, because Congress has caved into cronyism and rights holders, lobbyists, that they are continually disregarding the original founding purpose of that clause and expanding copyright protections, expanding patent protections into areas that it doesn't belong, and that, in fact, are doing exactly the opposite of promoting the useful arts, promoting the sciences. So we'll see some examples of that as we go along. What's a trademark? Well, you know what a trademark is. A trademark is a distinctive motto or a mark that is affixed or stamped onto a product so you know what that product is, right? I mean, you know by the shape probably that this is an iPhone, but if you look on the back of your phone, you will see the little Apple logo or the little Samsung logo or whatever the brand name is of that device, right? Because you know what a trademark is. A trademark is protected. You can't go around using someone else's trademark in the same line of work. Now, on Tuesday, Sarah's going to tell us all about this Coke versus Coke case, all right? So you're looking forward to that, and I know I am, so I don't want to spoil it, for that. Who is this? No, it's not. That's me. I had him reshoot it. Well, how do you know that's Michael Jordan? It doesn't give you any detail at all. It's just merely a silhouette of a guy jumping up in the air with a round hand. It could be a ping pong paddle or something, right? Or the moon. I don't know. How do you know that's Michael Jordan? Anybody want to tell me why they think that's Michael Jordan? You guys didn't hesitate. Because why? You've seen the brand. Some of you never saw the guy play. But you've seen the brand. Because that's a famous mark. Now, if I just took that mark and said, Maranatha has a new logo coming out, and it's this, right? And even if I reshoot it so that it really isn't me, but it's like, I don't know, whoever you want us to use. We'll get Matt Reeb. He likes to try to jump up in the air. So, we'll get somebody like that, and we'll take our own version of the picture, but it ends up looking like this. Do you think that's going to be trademark infringement? Well, let's ask ourselves, is it trademark infringement or not? In order to be infringement, it has to be confusing to consumers. You have to be able to show that there is a likelihood that consumers will be confused. So, if we just go and make that our logo for our university, Michael Jordan's not in the university business, so there is that side of it. But his brand has kind of gone transcendent. And so is it possible that people might think that somehow Michael Jordan is sort of endorsing our university if we made that our logo? Yeah, I don't think we would get away with that for very long. Even though we're not in the same industry, but there has to be a likelihood for confusion amongst consumers in order to prosecute a claim for trademark infringement. Now, trademarks have to be registered. That's why when a trademark is registered, what do you see next to it? There's a symbol that you see. Anybody know what it is? What's that? TM is one of them. TM means trademark but not registered. TM means I'm claiming this as ours, but I haven't done any of the work. All right? Now, you can do that. You can do that. It limits your protections a little bit. But what's the other one you've seen? C, all right? And then what? What else? A little circle around it. Okay, that's one of the other ones. But actually, that's not trademark. What is that? Copyright. We'll talk about that in just a minute. What's the third one that you might have seen? R. With what? A circle. Okay? These are the three that you're going to see on things. If a trademark is being claimed, it's a TM. If a trademark has been registered, it's a circle R. Okay? And you must register it within 6 months of its use. In other words, if you register it, you better start using it within 6 months or have already started. That trademark registration gives everybody notice because you're going to register that with the U.S. Patent and Trademark Office. And that is a searchable database. It's kind of fun. You should go on uspto.gov and you can search any patent, any trademark, anything that's been filed. And you can see the kinds of things that people have come up with. Go search Maranatha on uspto.gov. I doubt you find anything we registered. We don't ever register anything. Yes?
How do you register it as a logo?
So the same way. Because you can register, that's what a trademark is, a logo, right? And, here's the thing. I got into this with some clients one time. There's really two aspects of your protection, right? The first aspect is the fact that our name as an institution is Maranatha Baptist University. Okay? Just the text, Maranatha Baptist University. That can be protected and trademarked. But then there's also the style, right? The design of it. And so our new logo that you see like behind on the chapel stage and things like that, and you see it all over. You see the little shield logo on your handout that I gave you, the bottom left. We could trademark that in association or use with. Now, when you register it, you have to tell them what industries you are claiming protection. So we would be saying we use this in higher education, we use this in online marketing, we use this, and we would go through different, and they're all coded, almost like a doctor's office code. Every industry has a code. That's why it takes special lawyers to operate in this field. I cannot take on clients to do trademark and patent work. You know why? Because there's a second bar that you have to pass as a lawyer to join the what they call the patent bar. It's actually trademarks and patents. And you have to have an engineering degree in order to do that. Not only a law degree, but also an engineering degree. And I don't. And I don't want to have an engineering degree because it's so technical. And it's very, very detailed type work. You have to do the sketches and all of that has to get put in. So trademarks, you file them within 6 months. You get protection for many, many years. Let's see. What do you get? You actually get 5. Let's see. Renew. You have to renew it between the 5th and 6th years. And after the initial registration, then you can renew it every 10 years thereafter. And there is no limit on how many times you can continue to renew your trademark protection, except that the use requirement continues. Okay? So you think about like Crystal Pepsi. Did you ever notice that every once in a while they come back with these ridiculous brands? Or Mountain Dew will do a throwback can for about a month. Have you ever noticed that? Oh, isn't that a great marketing trick? You know what they're really doing? I know what they're really doing. They're keeping that brand alive. They're reviving it within their renewal periods. That's what's really going on. Now you know. Okay. Now they probably do get some extra money from that, but it gets a little bit of a spike. But they know that's not their core brand. They're not going to keep that on the market. But they're just being able to say, every 10 years or so, we use that product. And they keep it alive. Okay? Now, switching gears one way, trademark dilution is a bit of a new theory. A bit of a new theory. It needs work legally. Because whereas trademark infringement, you had to show that consumers were likely confused, trademark dilution says, this guy's not in our industry at all, but he is taking advantage of our famous brand, and he is using our goodwill in his shoddy product, and it's making us look bad, even though he's not even in our industry. Okay? So it's the kind of thing where in trademark infringement, if you could show that you were completely outside of the same market, you could use the same brand. Can anybody think of 2 famous brands that have the same name but in completely different industries? Can you think of any examples like that? How about Delta? What's Delta? What company is Delta? Delta what?
Airlines.
Airlines? Huh. What else is Delta? Faucets. Did you know that? Delta is one of the most famous faucet companies that there is. So, is that the same company? They just are in very different fields and make faucets and airplane rides. I wonder, you know what, I never paid attention on a Delta flight, but next time when I go in the bathroom, I'm going to see if they use a Delta faucet in the bathroom. They're not the same company, yet they exist. Huh. How do they do that? Because there's no trademark infringement when there's no likelihood of consumer confusion. And so when you go to Delta.com in 1999, you got to the faucet company. They had the domain first. Now you go to Delta.com and you get what? Delta Airline, which you were actually looking for. Same with Southwest. They used to be LUV.com. That was their big thing. They were the love airline, okay? Because they didn't have Southwest.com, and they had to get it. They had to negotiate for it. Same with Delta. They finally said, you know what? That website's worth more to you as an airline for booking flights than it is for people looking for faucets. Because Delta doesn't even sell directly to consumers. They go through the Home Depot and other kinds of things. So I'm sure they made big money on the sale of that website to Delta Airlines. You can have the same name as long as you differentiate your product. Sometimes when that happens, they'll be very clear to say, have like a link. Now, if you're looking for Delta Airlines, click here. Why are they doing that? Out of the goodness of their heart? No, because they're trying to keep their name and keep it protected. So that's the idea with trademark infringement. Dilution says we don't have to go to that step if our brand is really famous and their product is hurting our famous brand name, even though they're not even in the same market as us. So it would be like this. If Maranatha is super well known, and we are the greatest university in the world, obviously, and then somebody comes up with a brand of those hoverboards called Maranatha hoverboards, okay, and sure enough, just like all the rest of them, they burst into flames if you actually use them. Or plug them in, or even unbox them in one case. The guy just took it out of the box and within minutes, boom, on YouTube. And we say, you know what, people are a little worried that we're worried that because of this shoddy product that's being put out here, these Maranatha hoverboards, it's hurting our famous and prestigious university brand. We would not be able to claim trademark infringement. We would have to argue trademark dilution. And that's the case, I don't have to show a likelihood of confusion amongst consumers. That's also why I say this is in need of help, because it's becoming what was supposed to be a small little thing for really famous brands. Now, everybody's famous, they think. Oh, well, we have a website, so we're famous all over the world. You got 2 hits last year, okay? And the problem is it's threatening to become the exception that swallows the rule, because everybody ignores trademark infringement, goes straight to dilution. Now let's talk about what you ought to look for in a strong mark. When you're designing a trademark, you want it to be very distinctive. The more distinctive it is, the better. When I say to you Amazon, do you think about the river? Or do you probably more likely interact a little bit more with the website? What is the relationship between Amazon and what they do? Nothing. Nothing at all. Yahoo? Nothing. Google? Nothing. Those words meant nothing. Well, at least they certainly didn't mean what they mean now. Those words didn't mean that before. Even Facebook, okay, didn't mean anything until it was Facebook. Twitter didn't mean. Why are these really famous, if I said to you, what are the strongest brands in the world right now? Apple, Microsoft. Where did these words even come from? They didn't even exist at that level until these companies made them famous, right? That's the sign of a strong mark. A strong mark is something that is, if you can pull it off, arbitrary, made up, but memorable, right? Because if you can pull that off, if you can make up a word and attach it to you and your product and your brand, then you can literally dominate that market because you now are synonymous with that product. So, Microsoft is probably the most descriptive of any of those terms, right? But things like Xerox, Apple, Starbucks, Nike, these kinds of brands weren't anything until they made them something. Now, that's harder work. And in business terms, harder work equals more money, right? These companies spend billions on advertising their brands so that you will no longer think it's dumb that it's Google. Google, what is that? They even misspelled it. Okay. You don't think that's dumb, like people who originally... You know what the most famous original search engine was? Alta Vista. You've never heard of Alta Vista. Back when Alta Vista was on top of the hill, Google came out, and it was a couple of Russian college students, Sergey Brin and Alexei, whatever his name is, and nobody ever heard of them, and they thought it was dumb, right? Now, sometimes it backfires, right? Sometimes it doesn't work out so well. Some become more famous than others, but you have to spend a tremendous amount of money to convert an arbitrary word into an association with you, your industry, and your product. But that's what the strongest marks have accomplished. Some marks, in the next level or category, take a description and make that into their product name. So Southwest Airlines, London Fog. London Fog was a thing before it was jackets. Okay, it was the fog that they had in London. Okay, some brands are existing things that they try to bring over and make into their brand, and those are okay. But again, you're going to have some competition in that arena. And then some things just have general and generic terms, have no protection. You cannot trademark a generic term and say, well, our company that makes bicycles is going to be called Bicycle. Okay, great, but you don't get any trademark protection. In other words, you can't tell other people to stop using your word because that was already a thing. Okay, and London Fog can't tell people can't tell weathermen to stop remarking about the weather. Okay, and that particular